you cannot speak extempore. You must speak from a written speech. It is also said that whenever the president attends a dinner, it can never be a buffet dinner. It has to be a sit-down dinner. These are certain conventions which must be adhered to. And for me, it would have been a good excuse to read out, because I am in the presence of Mr. Jethmalani and Mr. Anil Divan, both of whom I have briefed when I was a young lawyer at the bar, and for whom I have immense respect. But then I feel I could as well give a go-by to this written script, because if I commit a mistake, I will have a defense counsel like Mr. Jethmalani and a counsel of Mr. Jethmalani, Mr. Anil Divan, to defend me. The chapters that I saw, you see, the subjects that were discussed, I was not here at the inaugural, I was not in the course of these discussions and sessions present to benefit from the discussions, but I feel the convention is, of course, titled the Rule of Law Convention. But I think the spirit of the entire exercise appeared to be to look at possible reforms that we need in the light of a resurgent India. Every patriot in this country, every citizen of this country dreams of India being a superpower. We all cherish that dream. There are certain features, yes, we will emerge as a superpower not only in South Asia but a world power. There are factors that strengthen that belief. We have enough to feed 1.3 billion people in this country. Those of you who are more than 50 years would remember, we used to import food grains from America under what used to be known as PL 480. And that wheat which used to come used to be second grade wheat, perhaps not good even for the horses in America, which used to be shipped to India for being distributed in the public distribution system. The country has done well. We have today enough stocks. We have a buffer stock that should take care of our requirements over the over 2 years, even if there is famine. But the negative part is that our farmers are, if not all, most of them still stuck with the obsolete, old, conventional way of farming. They need to continue producing more because India is growing. We have a totally a political army. We are a nuclear power. Our borders are safe. We are secure. But that is not enough. In our neighborhood, conditions are very volatile. Neighborhood remains disturbed. So we need to be constantly vigilant on the defense and the external affairs side also. We have a democracy, a parliamentary democracy, which the people of this country nurture. They have developed great faith in it. They cannot live without it. They will react to it. If anyone were to even in the slightest way undermine that great institution of democracy. But then the fact remains that our political system is caste-ridden. Money power plays its role. Regional and secessionist elements also have its influence on the electoral outcomes. That's a dragging weight, that's a negative feature. We are a young country. Young not only in terms of the life of the nation, we're just about 70 years old after freedom, which is very short in the life of a nation, but because also that almost 65% of our population is below 35. Europe is aging. Over next 20, 30 years, you will find the European population going down. Fertility rate is very low. While India will have such a huge youthful population which will produce, which will work, which will shine, which will give this country that glory which we very richly deserve after so many years of subjugation by foreign rulers. And last but not the least, we have an independent, a fiercely independent judiciary to maintain the rule of law in this country. But then, each time, the judiciary has to assert its judicial independence. You heard the Chief Justice yesterday speak that judicial independence is non-negotiable. The press has carried that news today. Should there be any need for the Chief Justice of India to remind the country or the powers that be that judicial independence is not negotiable? These are all the positive and the negative features. The fortunate part is, if you set off the negative against the positive, the net result remains positive, which means we will go ahead no matter. There are some negative angles, there are some challenges that need to be faced. We are, after all, going to be the largest, the most populous country in the world over the next 30 years or so. The world has started noticing you. Today you find the Japanese coming, the French coming, the Australians and the British coming, the Americans also extending a hand of friendship, because they realize that this country in Asia, or for that matter in the world, cannot be ignored. Today, every sixth human being on this earth is an Indian. But by 2050, every fifth human being will be an Indian. These are the signs of things that are going to come. This is the future. This is the resurgent India. This is the emerging India that we talk about. With these phenomenal changes will come many challenges. Imagine by 2050, 70 crore people, 700 million people will move from rural areas to urban areas. And that is twice the population of America. Over next 30 or 40 years, you will find as many as 70 crore people moving into the cities. Are we prepared for that? Can we provide dignified housing and accommodation in the cities for these people who are coming in search of jobs? Perhaps that is one reason why the government has this ambitious plan of setting up 100 modern cities in the country today. We are preparing for the future. Talk about judiciary now. With these changes and these developments, industrialization, the foreign direct investment coming, the foreign companies investing in India, and a host of other economic and commercial activities taking place, you will find the Indian middle class growing. You will find the awareness among the Indian population growing. The rate of literacy will go up. Affordability for litigation will go up. So what is the result? a huge burden is going to fall on Indian judiciary. Today, there are 3 crore cases pending in the lower courts, 1 crore in the high courts, or maybe 50 lakhs, 10 lakhs. 10 lakhs are pending, I think, in Allahabad itself. And with these changes and these developments, the number of cases that will come to the courts will be many-fold more. We all know the statistics. You read it every day in the newspapers. In practically every seminar, every convention and every symposium relating to judicial reforms, you will find these figures being recited. What this convention was, I feel, basically required and aimed at discussing were the reforms that we need to gear up for the future. Rule of law is an abstract proposition, and our commitment to upholding the rule of law is never in question. We have been reminded time and again, as Mr. Divan spoke to you about the rule of law, the times that we have gone through. Some of us treat those times as the darkest times in the Indian history post-independence. But that is just one commitment that we have made, that we will uphold the rule of law. And so long as Indian judiciary is there, you can remain assured that rule of law, which is the life breath of this country's democratic and republican character, will be maintained at all costs. But the question is, are we prepared for the future insofar as reforms are concerned, and what are the reforms that are required? I was wondering, should the reforms start from the bottom or should they start from the top? Today, you file 1 lakh cases in the Supreme Court. Nearly 1 lakh cases every year. There are 30 judges who are handling those 1 lakh cases. There are about 400 vacancies in the high courts. 400 judges are not appointed. If those 400 are also appointed, the filing in the high courts will go up to 1,50,000. And over a period of time, with 25% additional vacancies, it can go to 2 lakhs. With proliferation of laws, awareness, the affordability in litigation, the state support to litigation in the form of legal aid, that filing can go up to 5 lakhs. Let us assume in 2050, the filing is 5 lakh cases in the Supreme Court. What do? If 1 lakh cases are handled by 30 judges, 5 times the number of cases, does it mean you will have a Supreme Court with 150 judges? Is that what we are hoping to do? Is that the right thing to do? I think these are the issues that need to be discussed. Now, there are various options. If you ask Mr. Venugopal, he will tell you, well, we must have a court of appeal between the High Court and the Supreme Court. Why should even a 138 Negotiable Instruments Act case, where the person concerned is sentenced to imprisonment till the rising of the court, reach the Supreme Court? Why should the Supreme Court be bothered with anticipatory bail in a 326 or 325 matter? Why should anything for that matter which is less than death sentence be at all taken to the Supreme Court? Why can't it be held to be finally decided at the High Court level? Or at best, at the Court of Appeal level, if you set up one between the High Court and the Supreme Court. That is one way of looking at it. If you ask Mr. Rajiv Dhawan, he wrote a letter to me day before yesterday. He has addressed it to the Chief Justice. He says, let the Supreme Court sit in divisions, the constitutional division, the civil division, and the criminal division. Well, you can make divisions. You can have 5 judges sitting in the first 5 courts dealing with only constitutional matters. But does it stop the number of cases being filed in the Supreme Court? Will it bring down the number of cases being filed? Will it expedite hearing of the cases? We are today looking into the future, as we ought to, because you cannot start digging a well when the house is on fire. You must start doing something today, and the best platform for doing that is the Bar Association of India's platform. This platform, where jurists, all stakeholders can be invited, whether they are parliamentarians, whether they are lawyers, whether they are teachers, whether they are, ordinary stakeholders, let them come and contribute as to what should happen in 2050 when we will assume the filing in the Supreme Court will be 5 lakh cases. There are other options also. If you feel that 2 judges of the High Court can possibly commit a mistake while sentencing a man to life imprisonment, you can provide that, all right, instead of 2, let the matter be heard by 3 judges. If you find that, well, a second appeal should not be heard by 1 judge who can commit a mistake, you can say, let it be heard by 3 judges. There are multiple options. But those options need to be explored, debated, and a way found out. I don't think in today's sessions in this convention, this very significant aspect of our problem was discussed. Of course, we have always talked about training judges, we have talked about arbitration, we have talked about mediation, we have talked about other alternative methods of resolution of disputes. That is always there. But I can assure you, in the wake of the avalanche of cases that is going to come to the Indian courts over the next 30, 40 years, these will sound like cosmetic changes. They will not make any difference. You need to go for structural changes. You need to go for some structural reform. It is not as though we have to look to Australians or the British or the US or some other country to tell us. We have some of the most outstanding minds present in this hall today. Some of the most outstanding, some of the most brilliant persons who have, always dedicated themselves to the cause of justice, who have fought for the independence of judiciary, who have done everything that anyone could expect from a lawyer, because they have risen beyond those considerations of making a fortune in the profession. Why can't those people be invited to discuss and tell us? After all, it is not the problem of judges only. It is a common problem. It's a problem in which the lawyers are as much stakeholders, are as much concerned as the judges are. This is one area which I feel may not have been addressed in this conference, in this convention, but may be a very significant subject to be considered or discussed in any future convention if the Bar Association of India proposes to hold. Personally, I feel nobody else from outside is going to come and help you. You need not depend entirely on the Law Commission to tell us as to what are the remedies for our ills. I think the bar and the bench sitting together and debating these issues is going to give you the real solution. That is so far as the judicial part is concerned. But can we forget that even the profession needs some reforms? This judicial bandwagon cannot work unless the profession also is as well equipped, as professional, as honest and committed as the judges. You have maybe today 2 million people in this country who are practicing law. There were reports that about 300 people were practicing law in UP without a license, without a degree. The High Court had to institute a CBI inquiry into whether these people have at all qualified. It is like a quack sitting somewhere in Punjab writing Dr. Amrajit Singh, Ahluwalia, and poor farmer going and he giving him some, painkiller and treating him and fleecing him. unless the profession is also pure, how will the purity of the stream of justice be maintained? Professionals also need to be trained. The profession also must equip itself for the challenges of the future. I don't think in today's convention, in the past 2 days, the discussions and deliberations that you held, you talked about sharpening the skills of the professionals. But what about the ethical part in the profession? We need to look inside, introvert and introspection. Are we doing all that we ought to do as members of the bar, that noble profession where people would not charge money or demand money? There used to be a small pouch at the back of the gown where the client used to put whatever he felt or he could afford. That pouch is still there, but it is now stitched because the clients are not now asked to give whatever they can afford. The fees is demanded, in fact commanded, and the fees is phenomenal. Well, those who can afford, they can afford and they can pay, there is no problem. But can the likes of Anil Divan and Jethmalani or Salve or Rohatgi and P P Rao sahab who is sitting here, can they be afforded by an ordinary litigant today? I, as chairperson of the Supreme Court Legal Services Committee, I know each one of them has given their willingness to work free for a poor litigant. But this is a sacrifice that they make. Perhaps they can afford it. The question is whether generality of the profession is doing it. Are other professionals doing it? Has this message gone down to a person who is still struggling? Does he understand that my profession is not all mercenary, but it is also some amount of service to the cause of justice? How many of us are doing it? For they forget that those who cannot pay in terms of money can pay in terms of prayers. And prayers can be more helpful, can be more rewarding than money. I would therefore very humbly suggest to Mr. Anil Divan that in case this process of mutual debate, deliberations and discussion continues, it may provide enough food for thought for all those who can bring about a change. The change can start from here and now. It is a question of change of mindset. Let us not just live by the moment. Let us also look to the future, what the future holds for us or for the posterity. I think we owe it to the posterity that we hand over to them a system that works, that the people of this country have nurtured and valued so dearly that even today, despite the fact that it takes us 30 years, 40 years sometimes to decide a matter, they still come to us. They still have great faith. They find that if there is one place where they can open their heart, they can speak freely, they can expect hearing and justice, it is the court. Let us not let the posterity or the future generations down. Let us lay the foundation for a sound judicial system which we hand over to the generations to come. With that, I would thank once again Mr. Anil Divan for giving me this opportunity. I hope and trust that this process goes on and each one of us contributes to the process of the development of the future. Thank you. God bless you.
May I request the one and only Jethmalani to say a few words. Thank you. Mr. President
of this organization and my very distinguished counsel at the same time, our great and very graceful judge, Mr. Justice Thakur, others sharing this stage, and members of the bar, and I understand some law students as well are here, young and old. I was supposed to be speaking yesterday, and when I looked into the papers, I find that I was supposed to participate in that session which was supposed to deal with independence of judges. I'm glad I missed that, because so much has been written and said about independence of judges that I don't think that anything new really can be said, except a couple of things which I'll certainly share with you. And I looked into the papers of today, the 14th. I found that fortunately, for the last session, no subject is indicated. That's very good. It obviously means that you are inviting free speech. Now, my friend Anil referred to the good old days of the emergency. Let me share with you a few thoughts and memories about that most horrible period in the history of India. I was the elected chairman of the Bar Council of India at that time when the emergency was proclaimed. I did say to myself that I don't deserve to wear a gown and wear these bands if I can't speak up. And we thought that there are going to be extremely honest judges, independent judges sitting on the bench, and I was not wrong in my conclusion. Depending upon this belief, I accepted an invitation to go down to a place called Palghar, part of the state of Kerala. There was a meeting of the annual meeting of the Bar of Kerala. And I was invited as chairman of the Bar Council of India, and I had some colleagues from Delhi also sharing the stage with me when I attended that meeting. I vigorously, almost viciously attacked the emergency and the fraud that it was on the Constitution of India. But I could see even at that time that one by one the lawyers sharing the stage with me were leaving. I don't wish to give you their names. But it happened. But the police commissioner was there, the inspector general of police was there, judges were there, so on and so forth. Of course, all dictators are also incompetent. And I finished my job on that occasion, came to Bombay. The next